For my topic, I chose the subject of negligent misrepresentation. The reason I chose that is because it was an accusation made by Airbnb in their case against NGD Homesharing. NGD Homesharing LLC used Airbnb's logo in the sale of its developments without Airbnb's express permission. The definition of negligent misrepresentation varies by jurisdiction. According to California civil jury instructions, negligent misrepresentation is a separate and distinct tort, a species of the tort of deceit. And quote, where the defendant makes false statements honestly believing that they are true, but without reasonable grounds for such belief, he may be liable for negligent misrepresentation, a form of deceit. Washington civil jury instructions say there are two types of negligent misrepresentation, either an affirmative misstatement or a failure to disclose information. The Lanham Act, also known as the Trademark Act of 1946, is the federal statute that governs trademarks, service marks, and unfair competition. It was passed by Congress on July 5, 1946, and signed into law by President Harry Truman. The act took effect on July 5, 1947. A trademark is a word, phrase, logo, graphic symbol, or other device that identifies the source of products or service and distinguishes it from competitors. Some examples of trademarks are Coca-Cola, McDonald's, and Volkswagen. A service mark is the same as a trademark, except that it promotes a service, such as FedEx. The Lanham Act sets out procedures for federally registering trademarks. States when owners of trademarks may be entitled to federal judicial protection against infringement, and establishes other guidelines and remedies for trademark owners. The Lanham Act was not specifically addressed in the case of Airbnb versus NGD Homesharing LLC. However, the unauthorized use of Airbnb's trademark falls under the umbrella of multiple accusations made by Airbnb in litigation. Their goal was to terminate the contract with NGD Homesharing LLC. NGD Homesharing LLC committed multiple torts against Airbnb. If trademark infringement was a standalone accusation, the Lanham Act would most likely come into play. I think it's worth mentioning that Airbnb and NGD Homesharing are still working together. NGD Homesharing, later after this case of Airbnb versus NGD, brought their own lawsuit against Airbnb, which illustrates how hard it is to get out of these sort of things, which is kind of illustrated by this comic here, where this guy needs to pinky swear over his contract, which I think is kind of humorous. For my legal document, I used a template for filing an indemnity agreement with a hold harmless clause, since in theory, drafting and filing such a document could prevent negligent misrepresentation by holding the indemnity harmless against liability for the indemnifier's use of trademark without the indemnity's express permission. In this case, the indemnity would be Airbnb and the indemnifier would be NGD Homesharing LLC. And NGD Homesharing LLC would be indemnified by their insurance purchase, which is included in the agreement. Once the form is filed, the liability of both the indemnity and the indemnifier is well outlined and creates a safeguard against surprises in litigation. This slideshow brought to you by NOLO.com, LawStreetMedia.com, California Civil Jury Instructions, Washington Civil Jury Instructions, www.uspto.gov. Thank you.